On Wednesday, the Supreme Court heard its last day of remote arguments. It considered a pair of cases on whether Electoral College members can diverge from their state's popular vote. Earlier this week, justices heard arguments on whether President Trump has to release his financial records. These all could have implications for the presidential election in November. Jessica Levinson is a Loyola Law School professor and host of the Legal Eagle Files podcast, and she joins me now from Los Angeles. Jessica, thanks very much for being with us. Two cases coming out of Washington and Colorado claim that legally binding Electoral College voters to the popular vote is unconstitutional. How did the justices respond to this argument?
Fascinating arguments this morning. Over 2 hours of arguments. I tuned in. I was totally riveted. And you heard the justices really struggling with these big constitutional issues. Basically, in the Constitution, in Article 2 of the Constitution that creates the Electoral College, does the language of the Constitution say that state lawmakers can limit the electors in their abilities? Meaning, does it say that they can force them to vote for the candidate who is chosen by the state? Or does it mean that the states actually don't have any power other than appointments, and that these electors are free agents and essentially can use their own discretion? There's not a clear-cut partisan winner or loser in this case. So it was fascinating to hear the justices, kind of talk about, well, what was the original meaning behind the Constitution, and what have we done for centuries, and are there any other cases that are on point? Really interesting. I'm not sure that it's clear where the justices are going to come out, given the oral arguments.
So if electors are no longer legally required to vote in accordance with their state's popular vote, how could that potentially change elections in our country?
Well, let's imagine that you are in a topsy-turvy world called 2020, and you're going into a general election, and it looks like it might be a really competitive presidential election. And as we all know, there are 538 electors. You need 270 to win the presidency. And if at the end of election night, the first Tuesday in November, people are looking at themselves and saying, I'm not really sure if I like how the results went, and it only takes 2 or 3 or 4 electors to change the result, then we could have a very serious situation where, one, we have weeks of incredibly intense lobbying of these electors if it's close, where there's enormous political pressure put on them. And two, you could have a situation where the vote according to kind of how you think the Electoral College would go actually doesn't go that way. And so a few people could change the votes of really millions of people.
Right, really some profound implications here, potentially. Let's turn to Tuesday's arguments. President Trump's lawyer argued that the president should be immune from state and criminal processes while in office, but Congress and the Manhattan District Attorney argued that no president should be above the law. How did the justices respond to both arguments?
Right. Well, so there are 3 cases. 2 of them deal with congressional committees, and these congressional committees subpoenaed President Trump's accountant in one case and lenders in another case. And then there's a third case dealing with the New York State grand jury and whether or not they could subpoena the president's accountant. And so when it came to the congressional cases, I think, and it's hard to make too many predictions based on oral argument, but I think President Trump may come out ahead, because you really heard the justices struggling with, well, what's the limiting principle when it comes to Congress's power to investigate a president? What's the limiting principle when it comes to Congress's ability to say, I have a legitimate legislative purpose, and that's why I need that information? So you really saw the justices kind of pushing back on the attorney for the House of Representatives. When it came to that third case, the case dealing with the state attorney general who subpoenaed President Trump's accountants based on potential violations of state law, In that case, I think President Trump may not be as successful. A lot of really good conversation about, well, maybe the president is immune from prosecution or indictment, but does that really mean that the president is immune from investigation? Does it really mean that the president can prohibit his accountant from turning over information that does not deal with his presidency, but personal financial information that might have implications for other people, that might mean that if you don't get it now, the evidence will go stale, that might mean if you don't get it now that the defendants, other defendants couldn't be charged because the statute of limitations would run. So there's a lot more to say on this, but my guess is it might be a split verdict. President Trump wins when it comes to the congressional committees, loses when it comes to the state grand jury.
Well, this all comes just months before the 2020 presidential election. Do you think, Jessica, that is likely to influence the High Court's decision?
So, the justices obviously all have lifetime appointments, and that's for a reason. They're supposed to be outside of the political fray. I will say this particular Supreme Court, I think, is extremely excited not to make big news going into an election year, not to look like a political court. If there's anybody on the court who is really excited to play a game of dodgeball with a political hot potato, to mix all of my metaphors, and really avoid a big controversial decision, I think it's Chief Justice John Roberts, who you've just zoomed in on there in the middle with the red tie. And so one thing we could see is that when it comes to the cases dealing with the congressional committees, and that's the information that the public could see sooner rather than later, you might see the court punt. And they have two options. One, they could say, actually, this is a political question, and Congress and the president, you need to take this outside our house and figure it out for yourself. The other is that they could say, when it comes to congressional committee subpoenas that deal with the president, even if it's personal documents, you need a higher standard. So let's buy ourselves some time, send this back to the lower courts, and the lower courts will use a different standard. And then miraculously, after the election, at that point, we'll find out if these congressional committees can get the information. When it comes to the New York case, the state grand jury operates in secret. So it's not clear that the public would ever see that information before the election. Really look to Chief Justice John Roberts to try and cobble together a majority that avoids a big splashy headline, which includes something like Supreme Court hands the election to fill in the blank.
We will all be watching so closely. Jessica Levinson, thank you very much for sharing your insight and analysis with us. Appreciate it.
Thanks for having me.